Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Group. And the easiest way to get updates on what we're discussing is to go ahead and subscribe to the podcast on whatever streaming service you'd like. You can also listen to this podcast on our website, bracewell.com. Today, I am joined by I would say I'm joined by my two favorites, but I don't want to get in trouble with anybody else at the firm. But I'm joined by Navaro, a partner in our DC office, and Brittany Pemberton, an associate who's also in our DC office. They are my professional role models, occasional life coaches, and I've been peer pressuring them both to show up on the podcast. And today, my efforts have finally been rewarded, all for the benefit of our dear listeners. So welcome, Anne. Welcome, Brittany.
Thanks, Daniel.
Thanks, Daniel. That's a lot to live up to. And I have to admit that this is my first podcast, so I am very happy to follow your lead and learn from you.
Have you at least listened to a podcast, Anne?
I have never listened to a podcast.
Oh, no.
Okay. Do you even know what we're doing right now?
My 16-year-old daughter asked me this morning where she could find my podcast once it was recorded. And I said, how do you find podcasts?
There you go. Well, we're on all of the major podcast streaming services. We really should have built that into the intro as a natural way of talking about where you could find our podcasts. And you also mentioned something about wanting special theme music. Did you have your people talk to my people about that? Was that situation resolved?
Well, and I did. And so it's my expectation that you have the appropriate music to accompany this particular session.
Fantastic. We'll look forward to the finished product. So today, if Anne, Brittany, and I are able to actually stay on topic, which could be asking a lot, we're going to be talking about infrastructure projects and new federal approaches to the Clean Water Act and the Endangered Species Act. We'll also be thinking about what it means to design, permit, and defend major infrastructure projects against a pretty constantly shifting regulatory background. Some of this is coming out of a paper the three of us wrote together. And if you'd like a signed copy, we can obviously get you one of those. And I know while you'd rather hear from our guests than me as far as the outset of the podcast, what I do want to talk about briefly and my section of our paper, our article, was on the Clean Water Act's definition of navigable waters, which is pretty much everyone listening to us knows is defined as the waters of the United States or the territorial seas. Waters of the United States, or WOTUS, have been basically sort of like the environmental law equivalent of Hotel California. Litigation over this rule is perpetual. You can check out, but you can never leave, having to pay attention to what's going on in lawsuits over waters of the United States. So Anne and Brittany and I spent a lot of time following the previous administration's rulemaking efforts, first to repeal the Clean Water Rule, and then to issue a new rule defining what counts as waters of the United States, which sets the geographic scope of the Clean Water Act. If something is not affecting a water of the United States, then a lot of other regulatory provisions are not triggered under the Act and under the implementing regulations. The Navigable Waters Protection Rule, which was finalized in mid-2020 and immediately challenged, limited and identified 4 categories of waters of the United States and excluded about 12 different types of features from coverage under the Act. And many of you have followed what we have discussed in that area. That was immediately challenged. And it looked like, interestingly enough, that the current administration, the Biden administration, was going to implement portions of that rule while it underwent its own rulemaking activity. This is part of the paper where I think we wrote this over the course of July, published it in August, and here we are at the very beginning of September, and already the regulatory landscape has changed a little bit. At the time we wrote this paper, the EPA and the United States Army Corps of Engineers, which both have obligations under the Clean Water Act, EPA under Section 402 relating to discharges to waters of the United States, The Army Corps of Engineers administers the Section 404 program under the Clean Water Act, which relates specifically to discharges of dredged or fill material into waters of the United States. And that's an area of the Clean Water Act that we're really going to be talking about today, and that triggers federal reviews under the Endangered Species Act, among other statutes.
You know, Daniel, just to interrupt for a minute, and I was just sitting here thinking something maybe a little philosophical, but also self-evident, which is, you know, I've been around the Clean Water Act and the WOTUS definition for pretty much all of my career. And it's something that, you know, as you say, has engendered endless litigation, multiple Supreme Court decisions, now, you know, 3 attempts at a rulemaking, or really more attempts at a rulemaking, and still it remains very controversial and difficult for the courts to settle upon the scope of the act. You know, and it occurs to me in thinking about who the act applies to, we're kind of thinking about infrastructure projects, and a lot of our clients are thinking about infrastructure projects. But of course, especially Section 404 of the Clean Water Act applies to anybody who has waters of the United States on their property. So
That's
we've
right.
seen a lot of the more contentious and high-profile cases that have gone to the Supreme Court being brought by individual landowners.
And the Sacketts are back, right? Aren't the Sacketts going to get another bite at the apple?
The Sacketts are back, I think, in a couple of jurisdictions on this issue. And of course, the Rapanos, you know, were the lead in the Rapanos Supreme Court decision. So it just occurs to me that it brings kind of a different element when we talk about the Clean Water Act as opposed to talking about the Clean Air Act, which I know I'm never going to need a Clean Air Act permit at my house. Whereas if I have waters on my property and I want to develop it, I may need a permit.
As somebody who works on Clean Air Act issues, I say that you're probably right about that. And if that changes, then we have other issues.
Yeah, then we're going to have other problems.
Well, I know. I mean, if you're kind of shoveling dirt in the wrong direction, be sure that you're not sort of like throwing it behind you into a water of the United States, right? I mean,
right.
It could be that specific. That may not be EPA's or the Corps' highest enforcement priority.
Right.
In this sort of like legal connect the dots stuff. Yeah.
Yeah. You know, it's the intersection of regulation and private property rights that I think, you know, is one of the elements that, you know, make this saga so enduring.
Mm-hmm. And, you know, the phrase waters of the United States is, you know, confusing. It's not self-evident what counts as a water of the United States as opposed to, you know, a river that runs through my property or a creek or something more localized. What do we mean when we say this is under federal protection, especially when it's not, you know, the Mississippi River or something that is an interstate, you know, actual instrumentality of commerce. But, you know, this has been such a point of contention for people on both sides of the dispute of where we identify the Clean Water Act's jurisdiction. And so, you know, between the time we wrote this and today, we've seen a new decision out of the District of Arizona that actually purports to vacate the 2020 Navigable Waters Protection Rule, the Trump rule. And so that happened a couple of days ago, and that's been really interesting to observe. This administration, the Biden administration, had early on identified the Trump WOTUS rule as something that it wanted to look at. Very quickly said, we are going to repeal this rule and go back to an earlier set of regulations that date back to 1986, as modified by a couple of Supreme Court decisions. So the Biden administration announced that, and then they also said, well, we're also going to do a second rulemaking that it tries to extend protections under the Clean Water Act into more places. And so after those announcements, the Biden administration its typical posture in a number of cases where the Trump rule was being challenged by NGOs was to say, well, you know, we're going to ask for a remand without vacating the rule. We're just going to tell the court, hey, we're going to be fixing what we think is incorrect about this rule. And so there's no need for these proceedings to go on anymore. Just remand the rule back to us. Don't bother vacating it because people in the field are already acting on the 2020 rule and we'll fix the issue. And that had been what the administration wanted. And then just a few days ago, the District Court of Arizona actually granted the government's motion on remand, but did its own independent analysis and vacated the 2020 rule. So that's something that we've been following. And it's really interesting. I'd love to get your thoughts on that, Anne. We've been discussing the effect of that decision. One thing I think it does is it makes life maybe a little bit easier for this administration in saying, the 2020 rule has been vacated in part of the country, and so we need to take action. What are some of your thoughts on it?
Yeah, I think the question is, as I sit here this morning, a couple days after that decision, is what position is the government going to take on the extent of the vacatur of the rule? The plaintiffs in that case seem to be celebrating that the Trump WOTUS rule has been vacated nationwide. I can't say I'm confident that the government will take the same position because in previous litigation over the Obama era definition of waters of the United States, the government certainly recognized the potential for circumstances where district courts might arrive at different conclusions on the legality of the rule. And the Justice Department has historically taken the position that district courts, absent, particular circumstances, that their rules are confined to the parties before them and the geographic extent of their jurisdiction, essentially. So it will be interesting to see what position the government takes in the next few days. I think at present, things are in limbo, which I know is already frustrating to some folks out there who are trying to plan projects based on Clean Water Act jurisdiction. But I expect the Corps and EPA will issue guidance fairly quickly with their interpretation of that ruling.
Do you think they would issue that guidance together? I know that in the past, at various times, EPA and the Corps have seen things a little bit differently. I think that was maybe earlier on, but this would be something they do together.
No, in this instance, EPA really has the lead in terms of this aspect, in terms of interpreting, and defining 404, even though they do it jointly. And so they'll issue some sort of joint guidance and joint statement in terms of the scope of the rule. And then that will be rolled out to the different core districts. And in the meantime, I think there's obviously just going to be some level of uncertainty until they issue that guidance. Whether it applies only in Arizona or nationwide at this point, this is certainly where the Biden administration is headed anyway. And, as we've seen over the years, as the yin and the yang get more and more dramatic, this will be another one of those dramatic changes, especially in an arid state like Arizona, where it will bring back under Clean Water Act jurisdiction all sorts of ephemeral waters that are excluded under the Trump rule.
And that's one thing that I think was interesting about the court's decision. It kind of makes sense thinking about it, with sort of like a historian's cap on. It would make sense for this vacatur to come out of a state that was more arid, that was less protected as the Trump administration withdrew protections from certain types of intermittent and certainly ephemeral streams, which are just more common out west. And we had talked earlier about a decision in the District of South Carolina that granted the government's motion to remand the 2020 Trump rule without vacating it, right? That's a more lush area of the country.
Yeah. Even though even in those states, I think that under the Trump rule, a lot of wetlands were excluded from jurisdiction. But, I think the plaintiffs in Arizona think they've scored a nationwide victory. And I think that is yet to be seen, given DOJ's historic position on rulings like this.
And you mentioned the yin and the yang of, kind of going from one administration to another on these issues. And it sounds to me, reading between the lines, like there's really no reason for us to think that even once the Biden administration takes the actions that it's going to take with regard to the definition of WOTUS, that we're ever going to land on any real regulatory certainty in this area. Can you see a timeline down the road where that's going to be the case, where we've got a WOTUS definition and it's settled, not at issue in the courts, not flip-flopping between administrations? Or is that just a pipe dream?
Yeah, I don't. Can they edit my snort out of that?
No, that's got to
the
stay.
snort is precious. We need it.
I like to think that at least under the 1986 rule, as modified by Rapanos, things seem to be not settled, but at least kind of moving forward under that scenario, even though there were always individual cases like the Sacketts, and obviously others who wanted to challenge the applicability of the rule based on their specific facts, which is always going to happen. But, the optimistic side of me thinks that maybe there is a future in which, the Supreme Court becomes happy with a rule where eventually things will settle. But I think realistically, given the history of it, that's probably unlikely, at least during the remainder of my career.
One of the things that I think will be an interesting legacy of the Trump rule, regardless of its sort of status after Arizona, will be actually the preamble to the rulemakings. The Trump administration and the EPA and the court in those preambles made a number of legal arguments about why their position was correct, or at least why the 2015 Clean Water Rule really overextended federal jurisdiction to water features, wetlands that really weren't within the confines of the act. And it was a very statutory argument. It was interpreting Swank. It was interpreting Bayview. It was interpreting Rapanos and trying to draw pretty clear lines in light of the cases and in light of the text of the statute. And I could see plaintiffs coming at the eventual Biden rule reiterating many of those same arguments and asking the agencies to explain why they have a different interpretation of the case law and of the statute. So I think that's going to be part of the upcoming challenge to these rules. So it'll be interesting to see how courts receive these kind of changed legal positions from the agencies. So that's enough on WOTUS. There will be more. But one reason that WOTUS and the scope of Clean Water Act jurisdiction is important is that if Section 404 applies to a particular project and a federal agency has to make a decision on a 404 permit, then that federal agency also has to comply with various reviews that might be triggered, whether that's under the National Environmental Policy Act, the ESA, the NHPA. So, Brittany, what are we going to see on the ESA from this administration?
Sure. So unlike the WOTUS rule, unfortunately, I don't have a late-breaking story to share with our listeners about what's going on in ESA. Not much has really changed since we wrote that paper about a month ago. In June, NOAA Fisheries and the Fish and Wildlife Service announced that they would take action to rescind, revise, or otherwise, take some kind of reconsideration on some key Endangered Species Act rulemakings that were completed towards the tail end of the Trump administration, some in late 2019, some in late 2020. And the direction to do that really came from the top. On the first day of the Biden administration, the president signed an executive order that was all about protecting public health and the environment and restoring science and climate change and things like that. And the administration called out a number of Trump administration actions that the president wanted, various administrative agencies to take a closer look at and consider, a rulemaking process to rescind, revise, et cetera. On that list were a number of these Endangered Species Act rulemakings that the Trump administration finalized. And so, in June, we got this big announcement that the services would take affirmative action on a bunch of different areas. The rulemakings that they are looking to make some changes to, revising, rescinding in some instances, are really pretty broad. I mean, they tackle a range of issues under the Endangered Species Act that get to most of the big kind of, programmatic areas of the ESA, everything from protections for threatened species, listing decisions, critical habitat designations, Section 7 consultation. And, if I could paint sort of in a broad brushstroke what the effect of these actions was, it was really to try to, be a little bit more friendly, frankly, to infrastructure projects and to, proponents of those projects who are trying to get federal approvals. The ESA Section 7 consultation might be triggered by, some of those actions. And so it was to try to set up a little bit of a friendlier regulatory sort of environment for all of that. And at the same time, to really tamp down any real desire on the part of the federal government to look at the impacts of climate change in making these Endangered Species Act decisions and in authorizing these projects. So, for instance, one of the things that we're going to see in rulemaking, coming up here at some point in the next several months is rescindment of some regulations that revise the process for considering exclusions from critical habitat designations. And one of the changes that the last administration made in late 2020, the Fish and Wildlife Service changed the kind of evidence that it could rely on to exclude an area from designation. The statute, requires the service to consider the best scientific data that's available, as well as the economic impacts. So that's not an issue at all. But what the service did in changing the regulations was to allow information coming from third parties, and particularly outside experts, like experts hired by the proponents of a project, to provide the scientific data or the economic impact information about a listing decision.
That was almost sort of offered as or justified under sort of a transparency theory. We're not going to base our decisions on this economic information, but because this is really where the agencies are describing this particular decision, it's fair to include economic impact, even if that's not going to be a driver for our decision.
Yeah, I think that's right. And some of it is, conserving the scarce resources of the agency. They don't necessarily have the time and the money to spend to run all of these issues down. But as we see in, preliminary injunction litigation all the time, you want to look to the company that is the proponent of a permit or something like that, where there is Section 7 consultation going on, in order to, get an idea of what the economic impacts are, because the company knows best.
So, Brittany, why do you think, in terms of the economic impact information being available, opponents of these changes vehemently opposed that, because they said it was contrary to the statute to put that information before the decision maker? So if the agency said, well, it's just informational, we're not going to use it for decision making, why do you think opponents were so opposed to having that information available?
My guess is that they just don't believe that,
Right. That would be my guess.
They just don't believe it. It's hard to see into the souls of every, federal regulator out there and know what their true motives are, I guess. So another change that the Trump administration enacted that is definitely going to be on the chopping block are some changes to the regulations regarding Section 7 consultation and how we look at what's known as the effects of the action. The Trump administration really collapsed a bunch of concepts and terms into, a much more compact view of the effects. And, it's things like direct versus indirect effects and the concept of interdependence. Those are concepts that those of us who, work on NEPA issues or, are familiar with these kind of project development and siting questions, we're used to wrangling with and sort of divvying up the effects in terms of indirect and direct, for example. But the Trump administration just sort of collapsed all of that. And, with the net effect really being that it would be easier in theory for the services to avoid Section 7 consultation and considering climate impacts, because they would be considering, a much more narrow, quote unquote effects of the action. That's something that the Biden administration is certainly going to be interested in, given how much the president has put a focus on addressing climate change, as I mentioned in that executive order on day one. It's top of the agenda. And that's really a theme that I think runs through a number of these regulatory changes that we're going to see, is that there's this concern that the focus was narrowed in a way that makes it harder to consider what the impacts of climate change may be on species or on habitats or, in order to trigger Section 7 consultation. So clearly a priority, I think, for the administration in the next couple of months, year or 2 years even. And these changes are not going to happen overnight. They've announced, in general terms, what they plan to take on, including some of the things that I just talked about and more. But they have not given really a firm timeline on when any of this is happening. If you look at the federal regulatory agenda, that's sort of the twice a year kind of big announcement that we get from the Office of Management and Budget, really at the top of the admin world, about what the priorities are for the administration. And they'll put sort of loose dates in about when they think some kind of regulatory proposal is going to come out. It'll say, NPRN 070021, like sometime in July 2021, maybe. And where we are with these regulatory actions that we know are coming because both of the services, jointly announced them. Some of them were supposed to come out in July. It's now September. We don't have that. Some of them are slated for this fall. Some of them are slated for the end of the year. My guess is that we'll start to see some of these trickle out in the next couple of months, but that really all the timeline might be shifted back a little bit, and we're going to get into next year. And then it's going to take a whole year, probably, maybe even longer, to finalize everything.
And it seems like that's where these rules can run into some political headwinds too, because I think if you're going to be thinking about making new rules over the course of a 4-year administration, knowing that nobody really knows what the next election is going to look like, I think ideally you want to get your rules out, get your final rules out sort of by the middle of your first term. And then maybe you can have a couple of court victories saying, hey, this rule passes muster under the ESA or under the Clean Water Act. It's perfectly fine for an agency to interpret these phrases or these provisions this particular way. We give them deference under administrative law principles like Chevron, and then you at least have something stable.
For a short time.
I agree with all of that, right? But
Yeah.
I think what we saw with the last administration, with the WOTUS stuff and with other rules, is that if those rules are still being challenged in court and there's no real determination on the merits, you can find yourself in an interesting situation where, now we're talking about the reach of a vacatur out of a district court for one of the last administration's major policy initiatives.
Yeah, I mean, you raise a good point about the timing of these things. The bigger rulemakings are the ones that the current administration needs to try to take on now and in the next year for the reason that you pointed out, that you don't know what the next administration is going to do. And if you leave it to them to defend one of the keystones of your administration and one of the, big legacy pieces that you might have, I'm not saying these Endangered Species Act, rules quite rise to that level, but, you might find yourself up a creek, as they say, because, we've seen it every time the administration changes. There are lawsuits in progress and they always end up paused so that the new administration and DOJ and their clients can figure out whether to carry on. And then inevitably, voluntary remand motions come in because it's time to just take it back. And, we're going to take the football now and do what we want with it.
And I think already in this administration, I think a lot of stakeholders were hoping for, some pretty major rulemakings like the one under the National Environmental Policy Act to start earlier than it has, even though release of that proposed rule may be imminent. But so I think folks are already getting a little antsy about some of the major rulemaking and policy initiatives, given how complex they are, how difficult to finalize, and how likely they are to lead to litigation. Because I think everybody is very conscious of the need to do it well so that it will withstand all those challenges, but also to do it relatively quickly. It certainly seems like every administration, no matter how experienced, and I think the incoming Biden team has a lot of very experienced people, everything just takes longer than you want.
Well, so, if you're trying to design and obtain authorizations for an infrastructure project or some other kind of major project that has, Clean Water Act triggers of other federal reviews like Section 7 consultation or NEPA or the NHPA. What do you do? What do you do? How do you approach those kinds of projects when the very frameworks that you'd be trying to authorize your project under are in flux?
I think there's a variety of answers to that question. First of all, I think the bottom line is there's going to be some degree of flux. And I'm not sure I see that flux dying down anytime soon, given how increasingly polarized things have been getting. And so, when it comes to planning projects, obviously everybody wants to be able to rely on a stable regulatory regime, but it seems like we are less and less able to have any expectation of that. And so continuing to work closely with the agencies, following their guidance and executing your planning kind of in accordance with the current regime, but kind of understanding that things may change. And so having on your horizon perhaps bigger issues that may come into play, I think is really important. I do think most of the agencies, make a real effort to, even though change is coming, provide some regulatory certainty for things that are almost done now or things that were just finalized or just approved. So, for example, the Corps issues approved jurisdictional determinations, which per their policy are good for 5 years. And that's even if there is a regulatory change. Now, if there's a dramatic regulatory change, which it looks like there will be in the scope of Clean Water Act jurisdiction, perhaps that will be litigated over somebody's approved jurisdictional determination if they exclude waters from the Corps' regulatory authority that would now be included. But I think that the agencies do strive to provide some level of predictability based on the current regulatory regime. But I also think it's smart to look at the bigger picture and consider ways to include incorporation of issues that may be important in the public sphere, even if it looks like a change to the regulatory regime is coming.
I mean, it sounds like some of what you're talking about, liaising with your contacts at the Corps, et cetera, in order to follow their direct guidance about how do you want us to proceed for this project. But at the same time, keeping your eyes on the horizon for the bigger issues, all of that is sort of in service of making sure that the project has resilience, right? That you're not caught flat-footed, when there is some kind of potential big change, whether because of a change in administration or some policy change, that you've really thought about how you can address, issues that aren't issues yet.
That might mean asking an agency to look at effects that they might not be bound to look at, but that there's going to be a rule, that it's going to be finalized, and that process is going to take a year. Litigation challenging the rule, that may be another year, and that may not be within, your project timetable.
Right. And agencies don't always like that. I mean, it's not like an agency, will agree to look at something that it believes is outside of its current jurisdiction just to make you feel better. And so it can be kind of a complicated endeavor, even if your client and project thinks it's wise for an agency, for example, in its NEPA process, to consider issues that the agency believes are beyond its jurisdiction. And so then your project and your permit, obviously, there's some risk down the road if policies and requirements change.
Well, I guess all that we've really learned is that we just need to continue to stay tuned, which is a great reason to subscribe to our podcast, because I'm going to make Brittany and Anne come back on frequently because it's fun to talk with them about these things. Thanks for listening. Please email me at danielpope@bracewell.com if you have suggestions or complaints about our guests especially. And we will talk to you soon.